Hi there, this is estate planning lawyer Michael Pevney. I create estate plans for California families, and in this video I'm going to talk a little bit about how to pick a guardian for a child if you have a minor kid. But before this, if you have any questions relating to estate planning, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. And if you want more information about estate planning, you can like this video, you can follow me on this account and most other social media platforms. And please, if you have any questions about estate planning, go ahead and ask it in the comments. I'm usually pretty good about responding. So, how to pick a guardian for a minor. Without an estate plan, sort of the default system that's in place, if you and your spouse die, or if both the kid's parents die, if you're not currently married to the other kid's parent, what essentially happens is a set of court hearings. Your estate will go through the probate process, which can be very costly and time-consuming, and it can be a lot of hassle. It can be very difficult on the people that you leave behind. And as part of that probate process, a judge is going to appoint a guardian to take care of the kids, anybody that's under 18. And a judge is going to use the information that they have in front of them, the best information that they have in front of them. But they can only pick between people that step forward and say, hey, I want to take care of these kids. And so a judge is going to choose from those people that step forward. What they're not going to have is any information from you. So you're not going to have any say. Your voice is not going to be heard in that courtroom, and you're not going to know, obviously you're not going to know who's going to take care of them. You're going to be dead and gone. But the judge isn't going to know who you want to take care of those kids. So as part of a complete estate plan, something that I do with anybody that has kids under 18, we are going to nominate a guardian. So that can be done in a couple of different ways. The first way it can be done is in a separate document. Basically, it says nomination of guardian of a minor child, and we're going to set out who we want to take care of that kid. And it's always good to have someone in place, and then maybe one or two alternates in case that first choice is either unwilling or unable to serve. And the second option is you could actually do that in a will. Typically, I do it as a separate document because the main estate planning document that I use is a trust, a revocable living trust, and which is beneficial for almost all of my clients who are in California. A trust has a lot of benefits over a will. So we're going to nominate somebody using one of those two documents, either a will or a trust. And here are some things to think about when it comes to who is going to be that guardian. So first, I always say that you actually want just one person to be the guardian. That's not to say that you don't have alternates, but you want you want a single guardian, not necessarily a couple, because you need to think about what happens if that couple breaks up or gets divorced, or maybe one of them passes away. So maybe if you wanted your sister to be the guardian, and you wouldn't necessarily put the sister and the sister's spouse as the guardian, because what happens if they get divorced? Would you want, a judge is going to have to make a decision, well, they wanted them both to be the guardian and now they're not a couple anymore, maybe we move on to the next choice. So if it's your sister that you really want to be there, whether she's married or not, you put your sister as the guardian. And heaven forbid, if you had both of them as a couple on there and your sister passed away, do you want them going to your brother-in-law as an individual? That might be okay with you, and maybe you put the brother-in-law as an individual as an alternate choice, but if not, you should just have the sister as one single person, not necessarily a married couple on there. So some things to think about when choosing a guardian. First, you want to think about their age and their level of health, because you need to think about this person's going to be the guardian until your youngest child turns 18. So if your youngest kid is 2, in 16 years, how old is that guardian going to be? And what's their level of health? Do they have any sort of health conditions, anything like that might prevent them from being a good guardian? Second, where do they live? It's usually not very likely that the guardian is going to come and live and uproot their lives and live at your home with the kid. It's very likely that the kids are going to end up moving in with the guardian, unless you've worked this out with them, and if you own a home and there's a mortgage on it, you've set up a scenario, probably using a trust, in order to pay off or pay down that mortgage and pay for any maintenance fees, property taxes, that sort of thing. So where does the guardian live? And is that somewhere where you want your child to end up living? What is the guardian's family situation? Are they going to be able to take on another child? Hopefully you've also put in financial stuff for the kid to live on. Usually by using a trust, you have a solid trustee in place. That might be the guardian, it might not be, it might be somebody else. Third, we also want to think about what are the societal, the cultural, the religious values that you want your child raised under, and does the guardian share those? So those are always some really, really important things. And then the fourth, and maybe even the most important, is, does the guardian love your child, right? They don't have to be the most responsible person with money, because we can have somebody else take care of that responsibility, specifically a trustee, handle the money. But the personal relationship it's essential that it's good, right? So do they love your child? Do they have a good relationship? So those are some things to think about. What happens if you don't have an estate plan in place or a guardian in place, and some ways to think about what type of guardian you should have as part of a complete estate plan. So if you have any questions about this or anything else related to estate planning, you can visit me on social media. You can visit my website, which will be linked to here. Once again, Michael Pevney. I create estate plans for California families, and thanks for watching.